the penultimate point is that when the court draws the balance for itself, it also, of course, needs to take into account the other rights and freedoms of visitors, residents, and those working in the clinic. Those rights in Articles 9.2, 10.2, and 11.2. And I summarise those in our skeleton argument. It's Core Bundle, tab 6, page 69, paragraph 95, Roman numbers 2 to 4.
Core Bundle, tab 6.
Page 69, paragraph 95, and it's 2, 3, and 4. I don't propose to say anything further about them, but and I accept that they add to the article, the service users Article 8 rights.
So, the judge should have. Clinical these are your additional people, so clinical staff, residents in addition, but you've covered that this morning, haven't you? Really?
Well, I covered that in terms of they're having Article 8 rights as well, but yes, I have. I mean, I'm not going to say anything more about it. It was just, again, it goes into the balance.
Yes.
The second and final point is the manner in which the court should treat the local authority's own decision on proportionality with the convention rights, both in terms of the order generally and its specific terms. And as my Lord knows, the court is required, if it considers that analysis has been undertaken, to give at least due weight to the decision of the decision maker. May I take you to tab 10, which is the misbehaving authority. Decision of the House of Lords, and it concerned a decision by Belfast City Council.
I'm sorry, I was making a note. Which tab?
It's tab 10, my Lord. And pick it up page 163, please. The speech of Lord Roger. And the facts there were that Belfast City Council decided not to grant a sex shop licence to the appellant, having decided that the number of establishments in that area should be nil. It challenged that decision on the grounds that the council hadn't taken into account its Article 10 and Article 1 Protocol 1 rights. The Court of Appeal allowed the appeal because it hadn't done so, and then the House of Lords said that's not the correct analysis. It's not a question of judicial review, it is for the court itself to determine. But then it went on to say, well, what weight does one give to the decision maker's decision on those issues? And paragraph 26 of Lord Roger, he says, of course, where the public authority has carefully weighed the various competing considerations and concluded that interference with convention rights is justified, the court will attribute due weight to that conclusion, deciding whether the action in question was proportionate and lawful. And it refers to Lord Bingham, where he refers to, in such a case, it appears that such a body has conscientiously paid attention to all human rights considerations. No doubt a challenger's task will be harder. Then at paragraph 37, Baroness Hale, just below D, said, had the Belfast City Council expressly set itself the task of balancing the rights of individuals to sell and buy pornographic literature and images against the interests of the wider community, a court would find it hard to upset the balance which the authority had struck. But in that case, it had not done so, and therefore the court couldn't be assisted by its particular decision on that point.
But to strike the balance, giving due weight to the judgment.
That's right.
Yes. Much closer touch.
Yes. Then paragraph 47, Lord Mance equally says he associates himself with paragraph 37, and he says, giving due weight to such judgments as were made by the primary decision maker on matters he or it did consider. So perhaps a broader consideration, even if you haven't got it quite right, if you have looked at some of the issues, we'll give due weight to those. And finally, Lord Newburger at paragraphs 90 to 91 on page 178, having agreed with the analysis in paragraphs 37 and 45 to 47 in paragraph 90. He says, 91, because the issue involves careful scrutiny by the court of the decision, a counsel faced with an application for a licence would be well advised to consider expressly, misaligned. While the fact that a counsel has expressly taken into account Article 10 when reaching a decision cannot be conclusive on the issue of whether the applicant's Article 10 rights have been infringed, refers to Denby, where a counsel has properly considered the issue in relation to a particular application, the court is inherently less likely to conclude that the decision ultimately infringes the applicant's rights. And in this case, we would submit that the Murphy report carefully considered over a number of detailed pages with a lot of detail the convention rights engaged and the interferences considered. Just for your notes, may I give you it's the supplementary bundle, page 80, paragraphs 2.2.1 to 2.4.5.
Say that again.
Yes.
2.2.1.
I hate this number. 2.2.1 to 2.4.5. And then for the specific consideration to the proposals, it is page 98, paragraph 5.1.1 to 5.3.7. And when one looks at those paragraphs and sees the anxious consideration given by the council to convention rights, having engaged in statutory consultation, having engaged with all the various groups, and having come to a decision under this statute, which is in effect an exercise in local democracy, we say that due weight means considerable weight. Those are submissions on ground 5, and I now turn to Ms. Bogle for ground 6.
I don't know whether it's you I should ask this question to, or Ms. Bogle, but where does the judge ever consider whether the terms of the order are the least intrusive and necessary to give due weight to the competing rights? Is that something that Ms.
I think it's probably better for Ms. Bogle, because she was, of course, she was at the hearing as well.
Right.
My lord, my ladies, if I can address that specific question first of all, if one turns to tab 10, which is where one finds the judgment, page 133, paragraph 85, the judge has a section in his judgment dedicated to the terms of the PSPO. And I'd invite the court to have a look at the paragraphs beginning at 85 and specifically highlight, in answer to your lordship's question, that there is reference, not just in that section, but later in the judgment, to the Murphy report having correctly noted that the Article 10 rights were engaged and that the right balance had been reached. So in a sense, he pays deference or accepts the reasoning found in the Murphy report, which, as my learned leader has pointed out, was detailed and there was considerable time spent on assessing the rights, the way in which they were engaged, and whether the terms were of the order were indeed necessary to prevent the mischief that had been identified.
Well, I don't think there's anything in 85 as such which specifically mentions this, which is part of the proportionality exercise, isn't it? So I think it's item 4, as it were, of the 4 parts of the proportionality exercise. So, apart from 85, where else does he deal with this?
it's that whole section. So it's 85 through to 89. He dedicates to the terms, and he talks about how at 86 there's a suggestion. There had been a suggestion that the Good Counsel Network were the well-behaved group out of all these groups, and so somehow should be excluded from the order. And in 86 he says the reality is that such a solution would be completely unworkable, and that it would be impossible to identify with adequate precision which person belonged to which group.
So what he says is unrealistic, unworkable, is to exclude one particular group.
Yes, so that was one of the submissions that had been made before Mr. Justice Turner was, well, this order shouldn't be directed at the Good Counsel Network or those associated with it because they behave in an acceptable way, whereas it's the other groups that are the problem. It's the Friday group and the others. And forgive me. So that's what 86 is directed at. But later in the judgment, particularly 89, he notes the reference to the PSPO being of limited duration, reviewed after 3 years, and that the creation of the designated area had further mitigated the impact of the order on the convention rights of the activists. So is that
it? So I'm not saying that in a derogatory sense, but it's 85 to 89,
yes,
where he's considering that element of the proportionality exercise. Is that what you're saying?
My lord, yes, and in particular 89 is of significance because there he talks in the middle of paragraph 89 to the injunction was not aimed at depriving the applicant of his rights under Article 10, but merely restricting them in order to protect the rights of others. And he's made reference to Van den Dungeon in finding support for that proposition. Similar considerations apply here. Forgive me.
Did the judge, either at his own volition or at anyone's request, literally sit down and go through the order term by term?
I don't recall that exercise having been undertaken, and although it's my learned friend Mr. Havers has taken you to where one finds the arguments within the skeleton argument before Mr. Justice Turner, the reality is the thrust of the case put before Mr. Justice Turner was that there was no detrimental effect. And in relation to other alternatives, those other alternatives weren't directed to whether there was a lesser restricted form of words.
But whether there was something completely different.
There was a different power that could be utilised, and the suggestion that was being pursued was the use of the community protection notice. And you'll have seen the passage in the judgment where Mr. Justice Turner says, well, it's the same test that applies in relation to a CPN as does here, so how can one apply and not the other?
So your recollection is that the focus was not therefore on the actual order and the terms of the order, as opposed to some general criticisms of it.
That's absolutely right. And if one, I was going to take my lady to the reference, but if in answer to my lady's question in relation to how was the case put below, and was it accepted that there was detrimental effect, it absolutely was not accepted.
When you say detrimental effect, detrimental to whom?
To the service users and others in the locality. So the thrust of the case before Mr. Justice Turner related to the test, the statutory test, not being met because there was no detrimental effect. And one gets that from the skeleton argument that was before Mr. Justice Turner at tab 12.
The focus was on whether the local authority had power to make the order at all.
Yes, so it was an earlier stage in the process. There were criticisms of the balancing exercise with regards to convention rights, but the principal objection related to there being no detrimental effect, and it may be worth the court looking at tab 12 and the way in which that argument was put before Mr. Justice Turner, because I say it's indicative not only of the argument as it was put before him, but also of some of what's permeated the submissions that have been made to this court. And one starts at paragraph 33 of the skeleton argument before Mr. Justice Turner, at page 151 of tab 12. This is the section that deals with there being insufficient evidence for the defendant to have been able to conclude that detrimental effect existed. So it's my lordship's point about the power not existing because there was no detrimental effect. There are various observations made about the detrimental effect. In fact, it goes on for several pages. There's a single paragraph, 2 paragraphs on locality at 37 and 38. And then at 39 starts the section, the evidence of detrimental effect.
So it then goes through to page 160 with an their submissions that there was no judgment.
Yes, and what the paragraph I wanted to highlight in answer to my Lady King's question earlier was paragraph 47, because there they have various headings about why they say there is no detrimental effect. And at 47A they suggest that the evidence was one-sided. At 47B they suggest that the evidence is second-hand or anecdotal. See that the allegations don't differentiate between the two groups, and perhaps most importantly here, somewhat surprisingly in my submission, the thrust of the submissions were that the activities were entirely innocuous. Now, although my learned friend Mr Davies hasn't chosen to use that word and has sought to distance himself from it, that was the way in which the case was put before Mr Justice Turner. And I suggest that it's that downplaying, that belittling of the impact on the service users that permeates the submissions that have been made before this court. And I'll develop that submission in a bit more detail.
I'm so sorry to interrupt, but my own friend really should show you some paragraphs later on in the same document, the skeleton argument before.
Prohibitions in PSP are unreasonably wide.
Yes, beginning at paragraph 60. Put my glasses on. Yes, the paragraph 60. The PSPO is made is not sufficiently focused. 62, the terms of the order are extremely broad. And then 65 specifically, bottom of page 165, it would plainly have been possible to achieve the objectives of the PSPO by way of more focused restrictions and so on. So I'm sorry, but as I understand, it's not right to say that this wasn't raised before the judge. On the contrary, it plainly
I don't
was.
think that was set up in fairness to Ms Bogue. She didn't say it wasn't raised. She said that the primary focus was on detrimental, although it did in the skeleton argument.
Well, I'm sorry if I've misunderstood.
But
what
she
she was
hasn't
saying.
taken us
She
to it.
certainly hasn't taken.
She hasn't taken us to
No.
it, but she certainly didn't say it wasn't.
And in fairness to my learned friend, I don't seek to mislead in any way, but in answer to your ladyship's question, what was the argument before Mr Justice Turner? The arguments in relation to the specific clauses of the order. And
that's what I was asking, really.
Right, and that was the question I was seeking to answer, and in no way intended to mislead the court in relation to the case on that.
Just so I understand this then, the judge doesn't in his judgment consider the one breadth and two certainty of the specific terms of the order, because you say the focus of the oral hearing was at the earlier stage. Is that a fair summary?
That is a fair summary. That's not to suggest that there weren't any submissions made in relation to the balancing exercise in the context of convention rights. There were submissions made in relation to the Article 8 rights of the users and those matters. But in terms of how the oral argument was developed, it's fair to say it's in the skeleton argument. My learned friend has taken you to the relevant paragraphs. But that wasn't the focus of the oral submission and the way in which the matters were developed before the judge. And in turn, it's not surprising that Mr Justice Turner hasn't sought to do a line-by-line analysis of the order, because his judgment is reflected by the nature in which the submissions were articulated and developed before him.
I'm so sorry to intervene. Mr Henderson, who sits behind me, who conducted the hearing on behalf of the appellants below, tells me that he tried.
Right, I think we've got the point. So I think we can develop this in a reply.
Very well.
Thank you.
My learned junior hopefully makes the point that the line-by-line analysis that the appellants now seek to undertake is in fact analysis that Liberty have made in their submissions. These aren't criticisms that they themselves have made of this order, and perhaps somewhat surprisingly, but they now, as my learned leader suggested, have hitched their bandwagon to the submissions that Liberty have now made.
You're not suggesting that on this appeal it's not open to these appellants to make those submissions, are you?
I'm not suggesting that, my lord, and in fact we have sought to deal with those submissions because indeed if the appellants haven't made those submissions before the court, the intervener certainly has, and so they are matters before the court upon which the court will have to make a decision in due course.
Thank you.
So, my lord and my ladies, my submissions in relation to whether or not the PSPO could have been less restrictively drafted are going to be taken in three parts. Firstly, I will deal with what the case actually pleaded by the respondent, and I will deal with that very briefly. We've already touched on it. Secondly, I will make some general propositions that are of application to each of the clauses. And thirdly, I will make some specific submissions in relation to these specific clauses of the PSPO.
Thank you.
In relation to what was actually pleaded, unless your lordship and my ladies suggest otherwise, I'm going to take this by way of giving you some page references rather than inviting you to turn up specific documents, but I'll be guided by you as to what you would like me to take you to. As far as the way in which this ground of appeal is put in the appellant skeleton, we find that in the core bundle at page 41, paragraph 43. And the way in which they put their case is to suggest that it all depends on what the respondent's particular concern or principal concern was. It's core bundle 41.
Yes. Yes.
And it's paragraph 43.
Yes.
So, and the enumerated paragraphs in 43 relate to if the principal concern was, and then they identify, and that's the pattern that they've adopted throughout the course of 43. And whilst we're here, you'll see that their submissions on this point are limited to 3 paragraphs. So that was the way in which the case was pleaded. Is it a principal concern in relation to photography or display of images, if large crowds are physically impeding on entering? The simple answer to that proposition is that the respondent's concern was with each of those matters. They combined with each other, and indeed the concerns included all of the matters enumerated at paragraph 43, and all of the matters that have been identified in the Murphy report. You've already been taken by my learned leader to the Murphy report in paragraph 4.1.1. It's tab 8, pages 91 to 92. And that's the section of the report that lists the activities, that lists the evidence and summarises what the evidence suggests is the mischief that exists here. And one can break those activities down into much more than the 4 that are identified in paragraph 43. So they are about being approached on entry and exit. They are about attempting to engage in conversation with the service users, including when they exited, making reference to what had happened to their unborn child. They might have kept their baby.
Can I just see, we had a list, helpful list this morning from your leader, giving all the various matters which gave rise to the engagement with Article 8.
Yes.
I assume you rely on all of those points.
I do.
About 12 of them.
Would it be is your court content with your note on that, or would it be helpful for me to remind you?
Well, I don't want to get. We really don't want to go all over that again.
No, all right.
Helpful as it was, but let me just. I think there were altogether something like 12 points. Yeah, 12. He went through 12 points,
yes,
which he said set out the reasons for the engagement of Article 8.
I adopt those, and I give you 2 page references, my lord. One is to the Murphy report, paragraph 4.1.1, tab 8, pages 91 to 92, where you'll see the way in which the authority have broken down the various behaviours. And the other place where you'll find a list is in the Mary Stopes submission at page 50 of the bundle, where there is that long list.
Supplementary bundle.
It's in the supplementary bundle at page 50. So the simple proposition in relation to the criticisms made at 43 of the the appellant's skeleton argument is that had the local authority sought to omit any of those behaviours, it would not have served, the order would not have served to adequately protect the service users and their others' competing rights. In fact, the PSPO would have failed from the outset. What we then have is our liberty submissions, and of course they are the intervener, they aren't the appellant, and what they say hasn't founded this appeal, but it is right to say, as my Lord Atherton has already inquired of me, that I do say that the court must have regard to the arguments that they have articulated in their written submissions.
So I'm just trying to understand, so you're going to go on to the liberty points. I'm just trying to work out at the moment how I deal with your submission on 43. In 43, the appellants give four areas where they say that less restrictive conditions could have been applied. As I understand, is your point simply that there are only 4 there, but there are many others, or you're making a general point as well by saying, I think, actually, if you look at the 12 indicia that are relied upon by the respondents for the engagement of Article 8, it's clear, having regard to them, these wouldn't have sufficed. I mean, is that the point you're making? I'm trying to work out exactly which point you're making on 43.
I'm making both of those
Both
points, and indeed a third. So, although there are 4 aspects of the impugned activities which are criticised specifically, it's fair to say that Liberty in their submissions have made much broader criticisms of a number of other impugned activities as well as these 4. As far as this court's approach to matters is concerned, this court has to have regard to the criticisms in the round, whether they're made by the appellant or whether they're made by Liberty, because if the court is making this decision for itself, this is the exercise it will need to go through. But my it's not so simple, but the observation in relation to part 1 of my submissions is simply that this isn't the way in which the case was put when the matter was, this appeal was formulated, and it's only on Liberty having taken that line-by-line approach that we now will seek to address you on the specific terms of the order in due course. There are 2 points which are of application which we agree with as far as Liberty submissions are concerned, and they are that the clauses themselves must be sufficiently certain so as to enable citizens to know what they can or cannot do. And Liberty cite in their submissions a case in support of that proposition. It's the Hashman and Harrop versus UK decision at tab 8 of the authorities bundle prepared by Liberty. It's a proposition we agree with, and I simply give you the page reference. So it's the certainty, it's the need for certainty. We accept that. The second point that we accept is that the specific terms and the order as a whole need to be proportionate. And in the sense that what that means in this context is that the terms mustn't go further than is reasonably necessary to protect the Article 8 rights of the service users and others' rights and freedoms. And that's why that list of 12 is fundamental to the consideration of the specific clauses. What we say is that the particular evidence discloses that all of those items, all of those 12 matters, require protection, and that this requirement to be no more than is reasonably necessary is the overriding consideration when one looks at the specific clauses. And what one has to have in mind when making that assessment is the point that's been made on more than one occasion so far, and that is the precise location, the precise point in time, in the seconds before and in the second after having a medical procedure. So that point in time is important in the context of this order and the clauses that it contains. So the second part of my submissions are some general propositions which I say apply to all of the clauses of the order, and there are 5 points that I make here. The first is that in the Murphy report there are 8 references that I've counted to which demonstrate the approach of the local authority as far as the question of proportionality is concerned. My first proposition is that the respondent had the convention rights firmly in mind when it formulated the order, and it kept those rights under review through drafting. And there is express reference to this in the Murphy report, and I would, if I may, invite you to turn that up. It's the supplementary bundle, and it's page 83, tab 8. So at 2.2.22, the penultimate paragraph on that page.
2.2. Is it page 78?
83, page 83 in tab 8 of the supplementary bundle.
Oh, I see. 2.2.22.
22.
22.
The ECHR rights have been firmly in mind during the formulation of the proposed order. In addition, these considerations have been kept under review throughout the process of consultation and drafting. We then turn to page 86 for point 2. So my point 2 is that found at paragraph 2.4.4, the last sentence. The proposed PSPO has been carefully drafted to address the specific activities which are said to be having a detrimental effect on the quality of life of those in the locality. And this goes to the point that these are evidence-based orders. Ealing was acting on the evidence before it. At page 91, 4.1.1, we summarise, and this is the list I was referring to earlier, this is the summary of the various activities and the fact that their precise time and location results in detrimental effect. My point 4 is that when one looks at page 98 in paragraph 5.1.1 of the Murphy report, it says in terms, each of these activities, this is 5.1.1, each of these activities has been formulated by reference to the available evidence base. The existence of a detrimental effect is reinforced by the results of the online survey.
I don't have that. Oh, yeah, I see. I've got it. Thank you.
So we've looked at the detrimental effect in order to inform the prohibitions that we formulate. Point 5, we specifically look at give consideration to the issue of prayer, and one finds that in the report at 5.1.2, where we acknowledge that some might find the reference to prayer in paragraph, forgive me, 5.1.2 on the same page, page 98. The point we make there is that we are alive to the fact that some people might find the reference to prayer surprising. Indeed, there's been reference to laws that date back to the Elizabethan times. The point in this case is that the primary prohibition in clause 1 is on protesting, and they make the point at 5.1.2, the only prayer which is prohibited is that which amounts to an approval or disapproval of issues relating to abortion services. and they reference there the fact that 3 of the local churches have not taken issue with the formulation of clause 1 as it was finally
Does that mean
adopted.
even silent prayer? So you're not allowed silently to pray in relation to abortion?
Insofar as it can be said that it is expressing an act of disapproval or approval in relation to abortion services, it will be called. And the example in this case is that one of the things that GCN do is stand at the tree in direct line of the front door, watching service users go in and out, and either praying or have their hands joint in prayer, with or without rosaries, with or without signs. They're not saying anything to anybody, but what we have evidence of is that their mere presence is having a detrimental effect on service users.
So can I put this, the mere presence in silent prayer has a detrimental effect?
That is the evidence.
When you say that is the evidence, you mean that there is evidence of one or more individuals doing that, and then there is separate evidence of the effect it has on a user. Is that the way you're putting it?
Well, the evidence in a sense is a combination of the two, because the service user explains that this is what they've observed,
Yes,
and
that's
this is the
right.
impact it's had on
Yes.
them. There are instances of GCN themselves saying this is we have 1 or 2 or 3 people as the general modus operandi, if I can call it that way. The usual GCN presence consists of 2 or 3 people, one of which is often praying. Somebody might be at the gate. So even on their own case, GCN accept that prayer is an important part of what they do. And what we do have, so we've got their description of what they do, and then we've got the service users' evidence of what they say is happening and the impact on them.
I'm just trying to understand what this gets to. Obviously you can't hear prayer if it's silent. That's the point about silent prayer. It sounds as though, and of course we don't know what they're praying if it's silent. Nobody knows what people are praying if it's silent. But it sounds from what you're saying as though the very act of people standing and looking as though they're praying is itself a deterrent, or not a deterrent, it's itself having a detrimental effect, I think is your words.
Because one has to go back to the precise time and location in which that activity is taking place.
No, I'm not asking you to justify it, I'm just trying to make sure I understand the submission. So I'm trying to understand this question of scope and certainty. But it sounds as though what it comes to is if any person who is known to have a religious inclination is in the vicinity at all, that would have a detrimental effect.
Only insofar as their silent prayer was an expression of approval or disapproval of matters related to abortion. So if somebody was, well, if somebody's walking down the street reciting a prayer to themselves in their mind without making any noise, but they're walking down the street, that person isn't going to be caught by this prohibition, because it couldn't reasonably be said that they're expressing approval or disapproval of matters relating to abortion. The difference here is that these people involved in silent prayer are at the gate. They're in direct line of sight. They're with or with rosaries, and they're with or with people who are engaged in other activities relating to engaging service users, handing leaflets and the like. And in just as one example of the evidence in relation to the impact of silent prayer, one turns to tab 10 in the supplementary bundle. Tab 10 of the supplementary bundle, page 211. Paragraph 9. There's reference there towards the bottom of the paragraph to as soon as I walked through the door of the clinic, they started praying. I felt even worse. And there are other references that I can find should your lordship be assisted by them. And indeed, these activities aren't limited to silent prayer, because there is evidence again to suggest that the prayer is on occasion audible as well as silent.
I appreciate that, but it was just, I was taking up the point about the prohibition on prayer, and I was trying to investigate the extent to which that applied even to silent prayer, which your answer is it does apply to silent prayer, and I think your answer is because the presence of people who are known to be in prayer which is disapproving in some way is engages the Article 8 rights, and moreover the people in silent prayer aren't just on their own, they're connected with other people nearby who are doing other things, so you know that the prayer is disapproving. I'm not saying I agree with any of this, but I'm trying to formulate exactly what it is you're saying.
If I may say, you formulated it much better than I would have, but perhaps I can suggest that there is a graphic illustration of this in photographic form at page 71 of the supplementary bundle.
Yes.
These are people that, no doubt will be said, are engaging in silent prayer. And the location of the people in the white and black coats is in direct line of sight of the entrance, but not just the entrance, that blue front entrance door that we've seen in other photographs.
Yes.
They aren't there for any other purpose than to express a view about what is going on in that building and the people that are attending that building. And another example, because we're in the photographs, is page 70. This is the larger group that Your Lordship referred to earlier in the day.
Yeah, yes. It is the Saturday vigil.
This is an example of I don't know if it was a Saturday, but larger. There are larger vigils at other times of the year. So, for example, at Lent, there is a procession from Ealing Abbey to the facility. So, again, these are all people that could be said to be engaging in silent prayer. In fact, there's a lady there with her hands together on the right-hand side of that picture. This happens when it's very rare to see these protesters there on their own. This happens as part of their broader activity of seeking to engage people at the gate. And this is why page 71 is a typical GCN day.
But I think we've got to try and reduce this to some analysis. So, you know, when you have two rights that are engaged, and there's a tension between them, whenever you have two convention rights which are engaged, and on the facts there's a tension, the proportionality exercise, and one doesn't have priority over the other, the proportionality exercise requires you to do what is the least necessary to give effect to both of them. That's the way it will work. That means, obviously there's a spectrum there when weighing up on the facts, which has priority over the other. I don't mean they trump it, but in working out that proportionality exercise, which is a difficult fact-based exercise. But I think what it comes to is, I think you're saying that by virtue of the 12 matters relied upon for the engagement of Article 8 in this case, there's such a powerful case in favour of Article 8 that even silent prayer, which many people might consider ordinarily to be, you know, the least outrageous form, if I can put it like that, or least obvious form of protest, even that should, on the particular fact of this case, be prohibited. I think that's what it comes to. I think that's what you're saying.
That is what I say, and indeed I was going to make this submission in relation to the specific clauses of the order, but I'll make it now because it seems appropriate to do so, and that is that were this court to undertake a blue pencil exercise and decide that prayer and counselling, one or other or both, wasn't the least restrictive measure, wasn't part of the least restrictive measure as far as clause 1 is concerned, the removal of prayer is going to mean that there is going to be a GCN presence there the day after your judgment. because these groups do not consider what they are doing to be protesting.
Well, I think that is what it comes to. That even silent presence, you're saying, even silent presence is not on the facts and the facts here to be permitted in the carrying out of the balancing exercise.
In the very specific circumstances of this case, and indeed it's not a blanket ban on prayer as might be suggested, it is prayer in a very specific context.
Well, but being realistic, it is a ban on prayer, because if you say, if there's going to be somebody standing outside and they're praying, your point is they're obviously praying they're hardly praying to encourage people to have abortions, so they must be there praying for people not to have abortions, or praying for the dead souls of the fetus, I suppose. So I mean, we mustn't be mealy mouthed about this. It amounts to, in practice, a ban on prayer. It actually amounts to, effectively, a ban on presence.
It does, but that's precisely the point, because of the proximity and the precise time.
But you said it's still very possible to have certain types of prayer. I mean, that's unrealistic. The truth of the matter is that people are not going to be there, allowed to stand there in silent prayer. That's the reality.
Yes,
whatever the prayer may be.
Forgive me for interrupting. Indeed, we know that the order's being complied with. There is a presence in the designated zone where various activities are being continued with. Further, there is no restriction on prayer anywhere outside the safe zone. If they want to pray for the souls of the dead babies from Walpole Park at the back of the building, say for a small part of Walpole Park, they've got the whole park to go and pray in.
Is there any other case in which where Article 8 rights have rubbed up against, or there's a tension in Article 8 rights and let's say 10 or 11 or 9, where the court has said effectively that there's no right of presence at all to protest? I'm not saying there shouldn't be in this case, but is there any other case that we might get guidance from? Because it's quite an extreme position.
On that, I might back the wall back to my learned leader and invite her to do it at that point.
What a good idea.
If I may, my lordship. We've taken you already to those cases where there is a consideration of the balancing exercise specifically with regards to abortion-related issues. And it has to be in that context that one looks at the prohibition on mere presence.
Yes, I mean, I think your position basically is that the Article 8 rights are so strong here, and the circulars are so specific, that actually there isn't a ban on protest or presence at all, because you can still do that within the appropriate area that's designated, or outside the designated area completely. Then that's your point.
Yes.
I think that's probably a more attractive way of putting it.
I adopt that proposition, my lord. But so that prayer, does your lordship have any other questions in relation to specific reference to prayer? We were in the Murphy report, and I was simply identifying that the Murphy report has expressly faced head-on this issue of placing a restriction on prayer in this context. They've not sought to shy away from it, and they recognise that it's potentially problematic on first sight. My point 6 is going back to the Murphy report, so going back to tab 8, and this time to page 99.
You've got to point 6.
I have.
I've got generally on the order.
Yes, this is still in general in the order, and I said there were 8 references.
Could you just quickly remind me how we subdivided that?
Yes, so there were 8 references on the Murphy report.
Oh, right, yeah, I've got those.
Yes, so we're in reference 6.
Oh, I see, these are references. Yes.
And page 99, 5.1.3 at the top of the page refers expressly to careful consideration having been given to whether the paragraph on prayer could have been formulated differently. but it was felt that this was the least restrictive measure which would address the activities. We then move to reference 7, page 101, paragraph 5.2.5. In that paragraph, the local authority explained the rationale behind the scope of the safe zone. And there you'll find support for the proposition that's already been advanced earlier in the day, that the scope was informed by ensuring that the major routes of access were left clear. And officers, the second sentence in that paragraph, officers have considered whether the scope of the area could be smaller, but still achieve a protection for the persons affected by the activities, and have concluded that it could not. It's for this reason that officers conclude that the current proposed area, in conjunction with the designated area, strikes the appropriate balance between ensuring safe access for the users and enabling the represented groups to continue their activities on the other. So again, we find express reference to the balance being found in the Murphy report. And finally, my final reference is 102, at simply to say that at 5.3.4, the local authority has chosen to situate the designated area within sight of service users accessing the premises. Now, it could have decided to put that designated area completely elsewhere, or not to include one at all, but it's in recognition of the desire to be bearing witness and the other things that are said on behalf of the represented groups, that on behalf of GCN and those groups, pro-life groups, that there's been a deliberate attempt to accommodate their desires and to allow them to achieve what they would like to achieve insofar as it's appropriate in the context of the rights of others. And indeed, there's reference in the second appellant's witness statement to confirming that she can see users coming and going from the clinic, but she has to pay very close attention. And you'll find the reference for that is at Supplementary Bundle tab 23, page 339, paragraph 8. I've already made the point that clearly none of these restrictions apply anywhere outside the safe zone, whether it's to the text, to the images, to the numbers of people, or anything else. So in the second of my general propositions relates to Article 9.
Before you get to that, you very clearly identified the specific references between page 98 and 102, where in the Murphy report matters are drawn to the authority's attention. Is there, and I will check it myself when the hearing's finished, but is there a paragraph in the judgment which refers to this particular assessment? I can check it
in the
for
way
myself.
that I've just broken down.
No.
It's fair to say it's not done in that way, but he does quote large paragraphs of the Murphy report and the assessment, and the assessment and the respective balancing exercise. My ladyship, I wonder if I may come back to you on the specific reference in relation to the matters that I've highlighted, where the Murphy report specifically has regard to the balancing exercise, and where in the judgment one finds that.
Very well.
Article 9 was the second of my general propositions that I say applies to all of these terms, and one can find the local authority's assessment of that not just in the Murphy report, but before that in the equality impact assessment, which I don't think the court has yet been taken to. It's tab 11 of the supplementary bundle. that's where the document starts, and the document gives consideration to a number of the protected characteristics, including disability, race, and so on. The section on religion begins at 223.
Explain to me what this document is exactly.
It's the equalities impact assessment that the local authority conducted in order to assess whether or not those with protected characteristics would be affected by the terms of the order, and if they were affected, in accordance with its public sector equality duties, whether there were matters that reasonable adjustments that could be made and like to lessen the impact on those protected groups. And at section 7, religion and belief, this section, there is a section within the section that deals with religion and belief that I would like to draw your lordships and my lady's attention to, and that's at page 226. I'd invite the court to read all of this section after today, but the specific section that I highlight for present purposes is the section entitled Alternatives and Mitigating Actions, which have been considered in order to reduce negative effect. So the first point is that there is an entire section devoted to this. And what that section refers to are the attempts to negotiate a settlement as opposed to having to impose an order. It refers to the careful balance between religion and beliefs and the negative impact on others with protected characteristics. It refers to the need to keep the safe zone as small as possible. It says in terms that the order will be kept under review to ensure that the interference is no more than necessary. And in recognition of the interference, the local authority commits to undertake an extra statutory review of the order at the 6-month point. And there are no review provisions within the orders. The simple position is that they last for a maximum of 3 years. But they commit to doing this with express recognition of the impact on Article 9 rights. The third of my general propositions is that these provisions were not drafted in a vacuum. That's my headline point. In fact, the provisions were based in part on the Access to Abortion Services Act of 1996, enacted by British Columbia, and by some federal legislation in the US. And I have copies of those documents or legislation available for the court. They were before Mr. Justice Turner and have been provided, that the appellant has been given notice of our intention to provide copies to the court. I wonder if I could hand those up.
What is this going to show us?
It's going to show you that this language in this order has been used elsewhere. So we've taken the liberty of numbering the pages so that should your lordships be so minded, they can be inserted into the back of the agreed authorities bundle. And I'd like, if I may, to turn to 771, which is the British Columbia legislation, and we get that from the top of the page, British Columbia, Canada. It's the Access to Abortion Services Act, and over the page at 772, this act defines protest. About halfway down the page next to the second fold of the ring binder. Whilst we're in this legislation, it's worth noting the reference to sidewalk interference, sometimes referred to in the US as the pavement counselling, and just draw your lords and ladies' attention to that provision. And then at 773, under section 2, activities restricted in an access zone. So this legislation, one of the purposes of this legislation was to create a buffer zone or safe zone in the context of abortion facilities. The prohibited behaviours are at 2.1b, protest, and we've got the definition that I've taken you to earlier. And then at E, intimidate or attempt to intimidate a service provider. And just whilst we're in the legislation, it's a point that's relevant to a later submission in relation to the specific provisions. At section 5.2, the distance that was thought to be appropriate for the purposes of this legislation was 50 metres from the boundaries of the parcel of land on which the facility is located. My Lordship.
I'm slightly sceptical of the extent to which, when interpreting and applying convention rights in relation to members of the European Union, we're going to get much advice, much help from a statute of British Columbia.
My Lord, I don't. I take your Lordship's point. There are, of course, similar provisions protecting rights in the form of the Canadian Charter, which protect the right to privacy and freedom of expression and the like. But it's fair to say that these provisions haven't been drafted in the context of precisely the same provisions that we find in the Convention.
I don't know, have these provisions been the subject of cases in Canada?
I believe that they have, but I wouldn't be able to give your Lordship
That's
those
one of the
references.
problems. I mean, are we going to get this is always the trouble with comparative law. It can be very helpful. It can be very helpful, but it's normally not straightforward. So, I mean, I don't know. We'd have to rely on you completely on this. We certainly haven't got the time to do the research ourselves as to whether any of the provisions which you're drawing our attention are themselves the subject of debate or disagreement in the Canadian jurisprudence.
As far as I'm aware in my researches of these provisions, they have not been the subject of criticism, and indeed they were before Mr. Justice Turner, yes. And there's been no suggestion between that hearing and now that we were somehow wrong to rely on the language used in this statute or to take inspiration from the language used in other legislation. And no doubt if there had been a decision which had questioned the appropriateness of this language.
Well, this is a fixed 50 metres they're talking about here.
They are here. There are other pieces of legislation in Tasmania and Victoria, for example, which refer to a 150 metre zone. So part of this is about what one thinks is appropriate in one local area.
Of course.
And so the larger distances have been thought to be appropriate in other jurisdictions. Here, the local authority making local decisions based on the main points of access to this clinic have decided that 100 metres is the appropriate distance. So the simple point is that the distance varies according to what the local circumstances are, precisely the way in which local provisions ought to operate.
I don't think we would disagree with that.
The only point to draw from the other piece of legislation that's attached to that document that I've just handed up is that in the freedom of access to clinic entrances and places of worship legislation that applies on a federal level in the US.
Which page now?
This is 769, so it's the first page of that document.
Yes.
Under prohibited activities, there is the use of the words intimidates or interferes with. This is the second line under paragraph A. And attempts to intimidate or interfere with. It's a simple point, but these provisions have not been dreamt up. There was a basis for them.
Is the evidence that the local authority relied on these provisions?
They did because it. How can I answer the question without giving evidence?
I mean, is there evidence before the court? Is there evidence before the court that they relied upon these particular?
Whether they say so in terms in any of the reports, I would have to check.
Right.
In fact, I think there is reference somewhere to them having been based on British Columbia. I'd need to find the reference. But for present purposes, the simple point I'm making is that the language has been used elsewhere, albeit with other restrictions perhaps on rights and freedoms. And so there is some basis when one comes to specific provisions about the language used for words like intimidate or interfere with not needing a fuller explanation because they are plain English language words. And it's a simple point, but both of these sets of provisions don't seek to more fully define the terms that they use within this legislation. And so query whether Ealing needed to do any more. My final point before I turn to the specific provisions is, and in fact before I turn to them, one of Lady Justice King's question made an observation in relation to non-mould or non-molestation orders in the family law context, and we've been provided very helpfully with standard form of order. I wonder if this might be the appropriate opportunity to hand the document back. Could I ask you to give this back to Lady Justice King, please? Very grateful to you in having photocopied the provisions. The simple point here is that paragraph 12, there is reference to intimidate, harass or pester is the language used here. And again, it's the point I've already made in relation to the international legislation, which is that there hasn't been any need to give a fuller explanation of what those terms mean. Indeed, the words intimidate and harass are used routinely in the context of antisocial behaviour injunctions and the old form ASBOs that used to exist before this Act came into force. So my last point before I get to the submissions...
Used for ASBOs, and they're called what they call now, they're something else.
They're called... they're called IPNAs, or injunctions. Section 1 injunctions is the proper way in which to refer to them. Section 1 of the Antisocial Behaviour Crime and Policing Act of 2014.
Yes, but they're no longer ASBOs, they're something else.
They're not. They're injunctions now, and the equivalent for the bolt-on ASBO, which used to be called the CRASBO, is the CBO, which is the Criminal Behaviour Order. So equivalent provisions exist, but the tests are slightly different under the new provisions.
Is there wording in the Act that reflects these expressions?
The Act uses a different test. Forgive me, my lord, I didn't hear that.
I'm sorry, you said that the wording is similar to those used in the old style ASBOs and the current Section 1 injunctions. Are those words to be found in the Act?
No, so the test for triggering the making of a Section 1 injunction is antisocial behaviour. And Section 2 of the 2014 Act defines antisocial behaviour in two ways, depending on who the applicant is. Those two ways are nuisance or annoyance, fairly low threshold, one might suggest, or harassment, alarm or distress. Harassment, alarm or distress was the test that was used for the old form ASBOs. Those words aren't found in what the court needs to be satisfied of to make the injunction, but in making these injunctions, the words intimidate or harass are routinely found.
Well, okay. Is there a standard form of order we can see?
There's no such thing as a standard form of order, nor is there a template or any other suggested form of good practice, save for the suggestions that are made in various textbooks, which are, they are just the author's suggestions on what they consider to be an appropriate form.
I understand the force what you're saying. It doesn't sound as though there are standard forms of injunctions as for these molestation orders.
So in the non-molestation orders, one's got the shopping list, as it were, of things that one could pick from,
yes,
depending on what the circumstances warranted.
Yes.
An equivalent doesn't exist for Section 1 injunctions or...
So you're really just telling us about the Section 1 injunctions from your experience?
From my experience, having done extensive research on these provisions and having written a book on these provisions, and having suggested various template forms of words on these provisions. There are, and every individual has their own approach to the way in which they draft these injunction orders. The concept of certainty both for the recipient of the order and for the person enforcing the order are of course fundamental to those orders as they are to this order. So whilst the legislation itself doesn't use the words interfere.
Thank you.
A final point before I get to submissions on the specific clauses of the order are that there is nothing to suggest that the applicants in this case don't understand the form of words used in this case. In fact, the evidence suggests to the contrary. And if one looks at that evidence, we find it in the first appellant's witness statement, which one will find behind tab 14 of the supplementary bundle. And I take you to page 257, paragraph 47, first of all, where Miss Dulgheriu, the first appellant, says, in respect of Roman 1, the wording is so broad and expansive that I'm unsure exactly what activities or behaviours are covered. It is fairly clear that I will no longer be able to politely offer help to women outside the clinic, nor will I be able to pray quietly or even silently. Over the page at 258, paragraph 50, in respect of paragraph 2, again, this would prevent me from politely offering help to women outside. I don't know what sorts of behaviour will be covered by attempting to interfere, but again, presumably, I could be subject to criminal sanction for merely standing near to the entrance, not even saying a word. 51, the reference to harassing and intimidating, this again would prevent me from politely offering help to women outside the abortion centre. This would be the case even if the woman in question did not feel harassed or intimidated or welcomed my assistance. 52. In respect of Roman 4, I'm unsure whether this would affect my ability to record a member of staff or service user who I reasonably believed was or about to commit a criminal offence against me. So this is the prohibition that is said to be sufficiently clear, and indeed these behaviours aren't engaged in any way. That's obviously disputed, but this is what this appellant says about the order. And lastly, for 53, in respect of Roman 5, broad and expansive, it would prevent me from handing out a leaflet which detailed the support that Good Counsel Network could offer, or making any kind of offer of help verbally to a pregnant woman approaching the centre. And the background to this is the reluctance to accept that any of these things has a detrimental impact. So it's somewhat surprising for it to be suggested that the wording of this order isn't sufficiently clear. The evidence from Sally O'Brien, the operations manager, whose evidence can be found in the supplementary bundle at tab 11, at page 311, paragraph 20, is that she has seen massive changes since this order was brought into effect.
The supplementary bundle, tab 18.
Tab 18, paragraph 20. This is the sentence beginning, since the order came into force, we've seen massive changes. She refers to there being fewer cancellations, and at 21, she refers to a more general positive impact has been the air of normality which now exists outside the clinic, and this permeates the environment in a positive way. So, using your Lordship's words yesterday, the local authority isn't in a position to write a book about what behaviours are prohibited and which behaviours aren't prohibited. One would have an unwieldy order. What one needs to look at is how the ordinary, sensible person how they would view the order. So not fanciful people on the one side or skilled people on the other, but just the ordinary sensible person, and whether they would understand the words of the order insofar as the court is looking at the question of certainty. So the court's not going to need to redraft this order, but in giving consideration to whether or not prohibitions ought to be blue-penciled or otherwise completely removed, one would hope that the court gives some reasons for why those decisions have been made in order to inform this authority and others that may be in a similar position. The final point is that this particular order was consulted on.
This is point 4.
Point 5.
What was point
4 was in relation to the evidence doesn't suggest that the appellant doesn't understand. In fact, it suggests the contrary. This order was consulted on. This precise order was consulted on. And GCN make detailed submissions on what they say about these specific terms. And again, I'm just going to give you the page reference. It's tab 5, page 21, where they deal with each prohibition in turn. And should the court wish to see evidence of the form of order that was circulated for the purposes of consultation, the reference for that can be found in the Equality Impact Assessment. It exhibits it, tab 9, page 154. And it was also exhibited to the consultation report and the Murphy report that then went to Cabinet.
Were there any alterations made in the first draft consequent upon GNC's submissions?
There were. But they were inconsequential. They were tidying up, and there was a tracked change version of the order that was an exhibit to the Cabinet report. And it was very minor tidying up. So to the submissions on the specific clauses, and in dealing with each of the prohibitions, I can take the court, and I will take the court by way of simply providing page references to some specific examples of where one finds the evidence for this behaviour, and can take you to the specific page references should you wish me to. But insofar as clause 4.1 is concerned, this is the...
Should we now look at the order? Is that what
Yes, please. So the order itself is at 227 of the bundle. In the
Which
core
bundle?
It's in the core bundle, and it's behind tab 17. So what the appellants say about this order is that it's a blanket ban. It's failed to consider a less restrictive measure, and what they're not understood to be saying, at least not about this clause, they say it about others, is that it's too broad, unclear or vague. We say that even if they do say that, that's not a submission that's borne out when one looks at the wording of the order used here. They are plain English words. We say the meaning of those words is clear, and they have been used in other jurisdictions without further explanation. Further, what the appellant's criticisms fail to recognise is that the harm caused by the order, so this is particularly with regards to liberty submissions, they make various observations on the form of order, but there's no suggestion that they've actually been equipped with any of the evidence that the local authority had when making this order. In fact, there's no reference in liberty submissions to any of the evidence. The order, we say, is clear and enforceable, and the only addition to the language used by the British Columbia legislation, for example, are the words prayer and counselling, which we say are clear and unambiguous terms, but particularly with regards to the specific activities here, were they not to be included, there is a very high probability that GCN would return to the locality. Context, we say, is everything. So, whilst it's open to the court to take a blue pencil to these provisions, we would urge against the removal of prayer and counselling, because it's an intrinsic part of what the appellants do. And indeed, were the court to take that approach, one can well see, in a prosecution for breaching the PSPO, the appellants would pray in aid this court's judgment that prayer wasn't an appropriate form of words to include in the order. That's what I say in relation to Clause 1, and indeed the submissions in relation to certainty and the use of clear English language, I say apply to all of the prohibitions. In relation to Clause 2, at page 228, we see the reference to interfering or attempting to interfere, whether verbally or physically, with a service user or member of staff. To remind your lordships and my ladies, in relation to the submissions, they were that this clause is too vague. What does it mean? And my friend Mr. Havers said, well, does it include handing a leaflet and engaging in conversation? Well, yes, it does. It's precisely what it means. British Columbia refers to physically interfere. We use verbally or physically. The American legislation uses interferes with, or attempting to interfere with. Tasmania and Victoria use interfere with, threatening, obstructing, impeding. We say the use of physically or verbally makes it clear. We need the verbally because here the mischief is what is being said to the service users. In addition, there is evidence in this case of physical obstruction or impediment to accessing the clinic. That's the references we've seen earlier in both the evidence and the photographs to standing at the gate, standing at the doorway, walking between the two gate posts, women needing to walk around them. And there is evidence of verbal interference, calling women over, telling them they can't go in. So, query, what would be the lesser option here? We say there isn't a lesser option. It's obvious that it includes no leaflets, no engaging in conversation. And if we made express reference to leaflets and conversation, would they then try to use signs instead? Because one of the things, of course, is that if we prohibit or restrict one type of activity, what are going to be the attempts to try and do the activities that these groups want to engage in another form or another way? And so the risk of displacing the behaviour to another format is something that the local authority must be mindful of in drafting these orders. Again, context is everything. We say that when one looks at the activities, it is clear what this order and this particular prohibition is directed at. And in answer to my Lady Nicola Davies' question, well, what you say is that this clause is too vague and open to misinterpretation. We say, well, that may well be what the appellants say, but they don't give any examples of why it's open to misinterpretation. Indeed, Mr. Havers' question, well, is it leaflets and engaging in conversation? It is precisely those things. My Lord Etherton suggested, well, they could have a stand with some leaflets on it, and you're stopping them from doing that. We are stopping them from doing that because, first of all, that's not what they want to do. The evidence is that their key tactics are offering a leaflet, engaging women, because they don't want to give women that free choice of taking a leaflet or leaving it. That they want to be, that engagement is a key part of what they do. It's notable that they do not suggest anywhere in the negotiations, or indeed before this court, that a lesser restrictive option would have been to allow them to put a table outside and have some leaflets on it, free to anybody who chooses to take that information, because they are seeking to interfere with that free choice. The other point that arose, I think, in relation to non-molestation orders and the observations that Lady Justice King made was in relation to, well, does it make a difference if these are orders directed at individuals or groups? And on that point we say it doesn't, because orders of this type, which attach to the public space, are directed to the individuals within that public space. And so the overriding factor here ought to be the certainty and enforceability of those terms. regardless of whether they apply to an individual or more than one individual. On clause 3, intimidating or harassing, or attempting to intimidate or harass, the appellants say that's not formulated with sufficient precision, and that there's no link between the prohibitions and the activities in question. And the question Mr. Havers asked was, does that include talking to service users? Would that amount to harassment? Well, we say it does in the context of that being exactly what they complain about, as having a detrimental effect. I've already made reference to the international legislation, and in answer to, and indeed I've made the point I was going to make about the definition of antisocial behaviour within section 2 of this Act, which does use the word harassment without any further definition.
Section 2.
Section 2, subsection 1, little a.
Have we got that in the bundle?
We don't have that in the bundle, but I can certainly ensure that it's provided to your lordships if that would
What's
assist.
the context?
It's in the context of the definition of antisocial behaviour. So section 2 contains 2 definitions for antisocial behaviour, one of which is cause, harassment, alarm or distress, the other of which is nuisance or annoyance. And in fact, there is a reference to this provision in the White Book, if that would assist. It's volume 2, page 1320, should your lordships wish to look at it. So section 1 has created the power to make injunctions where there is antisocial behaviour. Section 2 then goes on to define what antisocial behaviour is.
Thank you.
So we say that what Ealing needed to do was to make clear that the behaviour that was objectionable, and what's suggested by the appellants is that we need to make clear that the behaviour was somehow objectively capable of intimidation or harassment. Well, there's no authority cited for that proposition. You take your victim as you find them, despite their reluctance to accept the impact on that victim. And that argument was run before Mr. Justice Turner, and he did deal with it at paragraph 34 of his judgment, and rejected the suggestion that somehow, because a victim might be more affected by a behaviour than another, that they should somehow be discounted. The detrimental effect is detrimental effect. So then I move to 4, recording and photographing of a service user or a member of staff. Liberty accepts that this is the proportionate clause.
As did Mr. Havers.
Yes, so the appellants accept that it could remain without the rest of the clause being, the rest of the order, even if the rest of the order was quashed, this could remain. I simply note that the evidence on whether or not photographs have been taken exists on both sides. It's disputed, but there is evidence before the court that was also before Mr. Justice Turner of both Sister Supporter and the GCN group taking photographs. That's why it found its way into the order. 5, displaying text or images relating directly or indirectly to the termination of pregnancy. Liberty say this is a provision that's strikingly overbroad. The appellants adopt those submissions and say that it's too broad, not particularised, and question what does indirectly mean. We could have been less restrictive by specifying fetuses. There's a submission that was made to the court, and that would have linked the activity to the prohibition. We say that as far as this prohibition is concerned, it needs to be read with the definitions found in paragraph 7 of the order. And this is staying in 228, where under the section which says, in this order the following words or phrases are defined as followed, displaying any text or images relating directly or indirectly to the termination of pregnancy includes, but is not limited to, imagery or textual references to abortion, baby, mum, fetus, soul, kill, hell or murder. So we say that that's a pretty full definition of what's covered in that particular prohibition. It cannot be said to be vague or insufficiently particularised. As to whether it's too broad, one has to go back to that list of 12 and consider whether the evidence that was before the local authority was sufficient to give rise to prohibition in these terms. It's not obvious, and nor have any submissions been made on this to indicate what would be the lesser form of words or a lesser form of restriction that is being suggested as an alternative.
What, it seems to me, looking in the round, what this all comes to, and I don't say right or wrong, the main part, but I'm just trying to make sure we understand the analysis. What this really comes to is that the sensitivities which result in the engagement of Article 8 in the first place are so acute in this case that nothing should take place which might upset those who seek to use the clinic. That's what it comes to.
Well, if we were to say that nothing should take place, we wouldn't have created a designated zone in
No,
our safe
nothing,
zone.
no, I didn't say that. I said nothing should take place which might upset the users.
I don't fully accept that proposition, simply because the activities in the designated zone, or indeed if they were to take place anywhere outside the safe zone, could still have an impact on the Article 8 rights of the service user. But we say that they're not at the specific time, location and point in the service user's life in terms of entering that clinic or exiting that clinic.
I mean, is there any evidence of them likely to be encountered outside the designated zone?
So they are operating in the designated area, so that's within the safe zone overall, and that is one of the main routes of access from South Ealing. So to that extent, it may be that service users walk past them when they're in the designated zone, but the point is, at that point, it isn't necessarily going to be obvious that they're about to walk into the abortion clinic. So they are still, some service users may still be encountering these activities, but it's a sufficient distance away that it's not at the precise moment in time when one is about to walk in the door. So we're not saying that they cannot be interfered with at all. What we're saying is they cannot be interfered with at all at this precise location. And in assessing this particular location, and indeed the viability of all of these clauses, one has to go back to submissions that my learned leader made yesterday about what is involved in a woman's choice to have an abortion and what it means both on a psychological and physical level to have had that abortion, because there will be women who leave that clinic bleeding, miscarrying their babies.
No, but I'm accepting that. So the point is, accepting your 12 points as to the acute sensitivity that applies in engaging Article 8. I'm trying to formulate what it is exactly that's happening here. Accepting that those are applied for argument's purposes, for the purposes of analysis. Accepting all those apply. You're saying, yes, nothing must be done at the precise location that is immediately access to and egress from the property, which would be upsetting to these users.
Yes. So there are examples of this legislation being used on a borough-wide basis, not in the context of abortion clinics, but drinking in public spaces might be an example. So the power exists to make much broader orders where the impact might be on a much broader level. Here, it is about this precise location.
I understand that, but of course at the same time, it's been repeatedly told in the law of the jurisprudence that the right to protest applies even where it's extremely annoying and upsetting for people. That's part of the right of protest. And there's plenty of authority on that. But I think what you're saying here is in this particular form of what being annoying and upsetting has a particular acute features. I think that's what you're saying.
It is what I'm saying. It's acute because of when it takes place and where it takes place. And that's what makes the impact on the Article 8 rights tip the balance when it comes to the balancing exercise, because we're not prohibiting any behaviours outside of the safe zone. And insofar as there is a presence within the designated area, there's no prohibition, for example, on the text that's used, on the nature of the images that are used, say for the size of them, and so but we're not prohibiting the exercise of those rights. We are restricting them only insofar as is necessary to give due weight to the Article 8 rights of the service users.
Right. So now you want to 4?
Just on to loud amplified music.
Yeah, 4, 6, yeah.
Liberty says strikingly overbroad, unqualified, and the like. We refer to the use of loud amplified music, particularly by the pro-choice groups. It is something that has happened and is a clause that is informed by the evidence base. There are instances of prayers on an amplified system, but those are so isolated that as to be insignificant. So it really is directed at the pro-choice groups and what they were doing. And we say the way in which the court ought to read this provision, in light of the criticisms that Liberty make of it, is to have regard to the remainder of the provisions in the PSPO as a whole. Because when one looks at what the PSPO as a whole is directed at, in the event that someone came before a magistrate's court having breached this prohibition, it would be obvious what the nature of the breach needs to be in order to establish a breach in this case. In any event, if there is a lesser form of wording or a less restricted form of wording, then that is something which this court itself can declare and suggest that it needs to be tied in specifically to the behaviours that are taking place here. But even if I'm wrong on the declaratory power, I say that your power, what you should limit your blue pencil to is this provision, as opposed to it contaminating your consideration of the rest of the order.
I mean, in theory, anybody who's walking along playing music or whatever, but passerby, nothing to do with either the protest groups or the users. In theory, they're committing a criminal offence.
The points made by Liberty are, I can see why the court might be attracted by those points, but it's fair to say that the order is directed at behaviour relating to approval and disapproval of abortion. And so that's why I say you look at it in the context of the order as a whole, rather than in isolation. I've made the points about the safe zone. My last point is in relation to the suggestion that the prohibitions that exist for the designated area could somehow be used for the whole of the zone. And I say, and one will find those at paragraphs 11 to 14 of the order, clearly it goes without saying that they're more restrictive because their location of the designated area is away from the door of the clinic. And that's why they are formulated in a different way. There isn't any limit on the contents of what's said, unlike in the zone. No limit on engaging or interfering with people. And the only restriction on materials is to the size of them. because what Ealing didn't want is to have the 2-metre high square colour images of aborted fetuses that are used by other groups. It was about ensuring that there wasn't a displacement of the behaviour in an effort to draw attention to their location. So it's not right to suggest that the whole of the order could go, but somehow the designated clauses in the designated zone would be appropriate for the whole area. It simply wouldn't be workable order to address the mischief that this order is directed at. I'm going to hand back to my learned friend to deal with the other question that the Lordship raised earlier, if I may.
My Lord, I think the point my Lord raises, are there any authorities where the courts had to grapple with the conflict between convention rights in a public space and where the balance is to be drawn, and are there exceptions? I'm afraid the answer is we're not aware of any of questions of that nature. It's not often to find a case where convention rights are, competing rights are engaged in relation to a public space in itself. The cases tend to be ones where protest takes place on private land or land to which local authorities have title, and therefore they have a right to possession at common law. And then in determining whether you give possession, which is all or nothing, you then, of course, take into account the Article 10 or 11 rights. Or they are equally cases where companies and the like seek injunctive relief against protesters, animal rights, fracking groups for protests on the highway. In those cases, their convention rights are not engaged because of protests on the highway. And so the court, when it comes to consider injunctive relief, is mandated by Section 12 of the Human Rights Act to pay particular attention to those rights in any orders it has made. But of course, that provision doesn't apply here because we're in a competing rights case. And the Supreme Court in PJS said that Section 12 doesn't apply in a competing rights case. It's simply weigh this one against the other. So I'm afraid I can't help.
Thank you very much.
Thank you.
Thank you very much.
Lord, can I say a few things first of all about the submissions that Ben made yesterday afternoon when he took you to the evidence at some length concerning detrimental effect and so on. Now, his submissions, the first one I want to address is this: his submissions seemed to assume, and indeed today in his submissions he confirmed, that his submission is that all the women attending the centre had firmly made up their minds that they wanted an abortion and were going to have an abortion. Can I show you some evidence to the contrary effect? And while I'm at it, that I can show you, your ladyships and my lord, in the course of that exercise, some more evidence as to exactly what activities, certainly these appellants and the GC network were engaged in outside the centre. Can I ask you first to go to the statement of the first appellant, which is in the supplementary bundle at page 249. Good enough to go over to page 250, beginning at paragraph 6 through to paragraph 17. She describes how when she attended this centre some years ago, not only had she not fully made up her mind, but she was assisted enormously by a member of or someone associated with the network, who engaged her in conversation, as a result of which she changed her mind to the extent that she made up her mind firmly about having an abortion. I don't propose to read those paragraphs out in full. Now I know that my ladies and my lord will have read them already in the course of pre-reading for this case. But then at paragraph 18 she goes on to describe the extent to which she seeks to engage with service users at the centre, and it's important that I do take the court to this because, and this is a general observation on my own friends' submissions, we submit that in many instances the activities that certainly the Good Counsel Network team have engaged in, he has overstated those activities to a significant extent. Can I pick it up at paragraph 19? The activity I'm involved in outside any abortion centre is very simple. I abide by the Good Counsel Network statement of peace, and without turning it up, that is the first document in the supplementary bundle which sets out, as it were, the rules of engagement. It's at page 1, tab 1 of the bundle. I will politely offer leaflets to women entering the centres, saying something like, hello, do you need any support? Now, just pausing there, these are not leaflets that are forced upon those who attend the centre, as was being suggested by both of my learned friends. They are offered to those who enter the centre. They don't have to take them. There's no obligation to take them. They can politely or impolitely refuse to take them. And then she goes on, she says something like, hello, do you need support? Again, that's an offer of support. She's not insisting on talking to the women who are attending the centre. And if the answer is they don't want any support, either they'll say no, or they'll shake their head, or they'll simply ignore her. In fact, she goes on, in some instances, I won't say anything, but women will approach me and engage me in conversation. I do not obstruct or hinder women from entering the centre in any way. The majority of women do take a leaflet, which is interesting, and some will stop to have a conversation with me. Many start telling me their stories, and some will say that they really don't want to go through with an abortion. I tell them about the help and support the Good Counsel Network offers. I tell them about my own experience and let them know that there is support available to them if they do not want to go through with an abortion. Many struggle to believe that the help being offered is real. They will go into the abortion centre but then come and speak to me again after they've had discussions about their options. Many will be very thankful to me for just being there. I cannot count the number of conversations I've had with women outside of abortion centres, but I would estimate for that every day I attend a vigil, I will have about 30 conversations with women visiting the centres. Just pausing, that's each day. She individually will have 30 conversations with women attending the centres, that's to say women who have accepted the offer made to them by the first appellant to engage in a conversation. If a woman does want support, I arrange a taxi to take them to the Good Counsel Network offices where they can talk about their situation further and see exactly what support is available to them. Can I pick it up 4 lines into paragraph 22? I understand that even thinking about having an abortion can be a traumatic experience, which is why I think it's so important to be there to offer help to women who were in situations just like mine. Paragraph 23, sometimes I attend vigils outside of abortion centres just to pray for those who are going into the centre. I know from personal experience how distressing the situation is at the centre, and I pray for those affected by abortion, both the women and for the unborn children, who I believe have life even in the womb. Because, she goes on a few lines further down, I believe that prayer can make a positive difference in the lives of those going into the abortion centres. Now that, I respectfully suggest, paints a very different picture to the picture that has been painted by many friends of the activities, certainly of the GCN outside this centre. I'll have something to say in a moment about the networks and the appellants' views as to activities which go significantly further than that in the context of what can and can't properly be prohibited. But that's the evidence as to certainly what these appellants and the network as a whole seek to do by way of engagement outside the clinic. Secondly, as part of the response of the network to the consultation exercise, they put in a pack of evidence. And can I take you back in the supplementary bundle to page 24? Which is a section headed Experiences of Women Encountering the Vigil on Mattock Lane. Just so that you get your bearings, as it were, if you go back to page 16, you will see that this forms part of the network's response to the consultation exercise. So from pages 24 through to 29, you will see set out the statements, as it were, not in conventional statement form, but I think I can fairly refer to them as statements nonetheless, of a number of women who have attended the centre and who explain that certainly they hadn't made up their minds in full or firmly, and that they found the offer of help to be of huge assistance. That is very much confirmed in paragraph 4.4.3 of the Murphy report, which you will find again in the same bundle at page 97. At the top of page 97, an important part of the pro-life group's position is that they have helped and supported numerous women as a result of their presence at the clinic. They provided accounts from the women they have helped as part of their evidence pack and response to consultation. Now, can I also hand up a short schedule of some further references in the bundles, which has been coming up, which was finalised.
Just to warn you, Mr. Hedges, you have to finish by 4:30, I'm afraid.
Well, I have a fair bit to say, and if I haven't finished by 4:30, I wonder if I might be permitted to put in writing what I haven't had time to say.
I'm afraid we don't really like that, so you'll have to make haste as much as you can.
Well then, my Lord, I'll say no more about the list that I've handed up, because otherwise I shall waste valuable time. Safe to say that you will see it's broken down into the objectives of the appellants, confirming and enlarging upon what I've read from the first appellant's witness statement, typical activity outside the clinic, and then the availability of counselling in the clinic. Then over the page, the number of people that GCN has helped over the previous 23 years. That figure of 3,000 was available in the bundle before Miss Justice Turner. We haven't yet located it, in the sense that we haven't copied it and brought it over, but I'm sure my own friends will tell us if we have misrepresented the figure. So can I then turn without more ado to the geography of the clinic, which is what my own friend then turned to. A short point, but important nonetheless. He showed you some photographs, again in the supplementary bundle. Can you go to page 323? So 323 was the penultimate photograph that my learned friend showed you. Now this is standing at the edge of the designated area, as I understand it, nearest to the entrance to the clinic. And as he pointed out, there is to be seen a lady with a sort of white-coloured jacket standing in the distance. I don't know if that helps if I put my finger up against my copy of the photograph. She's just to the edge of what looks like a pseudo-acacia tree to her
323.
to her 323 to her left and above her, obviously, and just this side what looks like two lions on top of two pillars, and that's the entrance.
Yes.
And it's a very, although it's said to be 100 metres, it's a long 100 metres, and the idea that people entering the clinic will be able to will notice, let alone pay much attention to people standing in the designated area is, we suggest, improbable. And then page 324 is the same. Is the position looking the other way? So this is taken from outside the entrance to the clinic, looking into the distance. And I suggest that you will all struggle to identify where the designated area is. The same woman is there, wearing that same jacket, but it is frankly impossible, or virtually impossible, to identify her. So the designated area is no substitute at all for the appellants being able to engage in the activities that they have engaged in outside the front of the centre. And of course, although my learned friends place great emphasis on the place where these activities take place, I'm sure the court will have taken on board that the place where the activities take place is no less important to the appellants. Frankly, being able to conduct any of their activities 100 metres away, which is far too far away, as I suggest the photographs show, is of no assistance to them at all.
Is it 100 metres in either direction? How does it work?
I think it's 100 metres from the designated area to the entrance to the centre. And the reality is that it will be, it's impossible for the appellants to engage with the women who attend the clinic at all. Thirdly, he showed you some evidence from the supplementary bundle. Firstly, clients A, E and D. I'm going to take this very shortly. We've made comments on their statements in a document in the core bundle of pages 92 to 93, and you'll be able to see our comments on their statements on those two pages. They're identified as clients A and D. You next refer to a clinic service user. We make comments in the same document at page 92 at the top of that page. The Marie Stopes employee, again, comments you will find at page 93. She's called Stephanie Gonclaves. And then he took you to the BPAS consultation response, and in particular, I think it's to be found around page 30 of the supplementary bundle, if you still have it open in front of you. Yes, it begins at page 30. And we would simply like to draw your attention to the bottom of page 31, which sets out incidents reported by activity. And if you look along the descriptions of those incidents at the bottom, standing by entrance, standing away from entrance, handing out leaflets, rosaries, praying, singing, chanting, shouting, staring, approaching clients, obstruction, following clients, displaying signs, posters, display aids, filming. Now, the majority of those activities we submit are unobjectionable. We accept that it is objectionable to obstruct the women from entering the centre, and we certainly the appellants never would have done so. We accept that filming is objectionable, and certainly following clients for any great distance may be objectionable as well. And thus we would accept that there are some activities, not activities engaged in by the appellants and GCN, but some activities which, if we lose on all our other grounds, the court could arguably conclude would be justified in terms of the balancing exercise.
Where did that give us to?
Well,
Just to say, yes, there are some. I'm not sure whether that fits into the analysis.
well, my lord, what I'm saying is that the vast majority of the incidents that are described at the foot of page 31 are reflected or reflect what is in paragraph 4.1.1 of the Murphy report, which my own friends rely upon, as you would have heard, as setting out the activities to be deduced from the evidence. So my point is that this is very simple, and this confirms what we submit is the non-objectionable nature of the activities in question. But we would respectfully agree with my Lord the Master of the Rolls a few moments ago that the position of the respondent does appear to be that any activity that upsets in any way at all any of the service users is intended to be prohibited under the order, and that was indeed their intention, and that, we say, is an extreme position and one that cannot conceivably be justified.
It sounds like the retort, not the retort, but the answer that I got on that issue was, well, their activity by way of objection or protest can still take place, but not at the axis. It can take place either outside the designated zone completely, or to a restricted extent within the permitted zone. But it sounds as though, in relation to the first part of that, you're saying that it's so far away from the entrance that it really is of no value whatsoever to anybody.
It is.
I don't know what you say there about what is permitted within the permitted zone.
I mean, my lord, the balance position on that is that that's really neither here nor there, because what is or is not permitted in the designated area doesn't assist them one way or the other at all, because it's simply too far away to have any meaningful effect. So, in a sense, it does come down to the importance of place.
Yes, so that's what it seems to come down to.
And that's why I began my reply early on by emphasising that the place where the appellant's activities take place is as critical to them, if not more so, than the place where the service users say they suffer detrimental effect.
Is there any evidence to back up the proposition you're putting to me, which is that what is now permitted under the order and where it is permitted is simply of no value whatsoever?
I'm sure there is, because of the shortage of time.
Perhaps your junior could look for
I'm going to ask my juniors, one of them, to list the references, and then I can read them out at 29 minutes past 4, if I may, rather than spend time looking for them now.
But I think that's important that there's some evidence about that, as opposed to you just saying that.
We'll carry out the exercise.
Thank you.
And more finally, before I get to what my own friend had to say about ground one, he accepted that, and this is important, that the service users only visit once or twice. So it's common ground that their visits are as limited almost as could be. Now, ground one.
And ground one is a short point.
It is a short point. My starting point is to submit that it would be remarkable indeed if the phrase "those in the locality" did not reflect the objective set out in the white paper, that's to say, to protect the local community, or the explanatory notes to the same effect, or the guidance issued following the Act, again to the same effect. So that's my first point. The second is that no help can be gained by reference to the definition of a public place, because a public place has to be defined somewhere in the Act, because the local authority can only make such an order in relation to a public place. So it's unsurprising that one finds that defined, because it has to be. The logic of my own friend's submission on that point would seem to be, well, if the Parliament, if that had been its intention, could have included the same or similar words in section 59(2)(a), rather than the phrase, those in the locality. But of course Parliament didn't do so. My Lord, just a point to note, my own friend did not address at all our point about the effect, that the requirement that the effect of the detrimental effect has to be continuous or persistent. I don't need to repeat the submission we make on that, but that's not going to apply to those who visit only or once or twice, is our short point. Bylaws, he says, this is no different to bylaws, but we would respectfully submit that generally bylaws don't interfere with fundamental rights. And then he addressed you on the what your power, what the courts.
It's correct, isn't it, that any infringement of any bylaw is a criminal offence? Is that right? That seems to be the proposition.
I haven't written a book about bylaws, and therefore I'm in a somewhat less advantageous position than my learned friend. But I have to take notice of your Lordship's question. I'd be surprised if all bylaws did, but in a sense, my Lord, that's nothing. My short answer is that's nothing to the point. We're looking at a statute that does create a criminal offence, and that's in a sense the beginning and the end. Lord, he made submissions as to the court's power to quash, and suggested you could carry out a blue pencil exercise and delete some parts of the prohibitions. We submit that's not a function that is open to you. There's no power in the court under the Act to vary any of these prohibitions. That's what it would amount to. Any such exercise would amount to. Power is given to the local authority to vary the terms of the order, but no such power is given to the court. And we would respectfully disagree with my own friend on that point. He said that a logical consequence of our submissions is that there would be no protection for single one-off users, even though they were detrimentally affected, or for those who return for similar reasons in the future. But the short answer is, and therefore they'd be unprotected, the short answer is that there are plenty of other forms of protection that can be provided, other powers available to the local authority. And if you, can I just give you the reference? It's in the Murphy report, not the Murphy report, it's later in the supplementary bundle, pages 236 and following.
That's for what proposition?
That's for the proposition that the logical consequence of our submissions is that no matter how detrimental the effect is, and no matter that there will be similar individuals attending the centre in the future on many, many occasions, albeit only once or twice, they get no protection from the PSPO regime. And our answer to that is, well, there's plenty of other protection that's available elsewhere.
So you would challenge the judge's findings under the section in his judgment when he looks at less restrictive alternatives and various options, various different statutes and things that
well, he was considering those as alternatives to the PSPO regime. But what the learned friend is saying is, and what my submission is is advanced on the premise that the PSPO isn't available, but that doesn't mean to say that there aren't other remedies that are. I mean, I'm going to have to leave it there because otherwise I'm simply going to run out of time.
So what do 236 and following show?
They show, supplementary bar, they show the range of other
Oh, I see. Options considered draft order.
exactly.
Whose document is this? What is this document?
This is part of the options. It's all part of the. It's an annex to the Murphy report.
Right, annex to the Thank you.
And then finally, he indicated what he says section 59(2)(a) means, and he says all that the definition is getting at, that's to say that the expression those in the locality is physical presence in a geographical area. That's how he put it. And of course that raises all the uncertainty of, well, what is the geographical area in question? That simply means that the question of uncertainty persists on his interpretation of the clause. A general point, if I may, about learned friend's construction of the section, which is that it necessarily depends upon an expansive rather than a restrictive interpretation of it. He suggests that just because there's a criminal sanction, it doesn't follow that that the construction should be stricter. We say that's a pretty elementary rule of statutory construction. Can I then turn to our ground 3? That's to say the engagement or otherwise of Article 8. The mention was made of cancellations of abortions as arising from the activities outside the centre, but it's important to stress that there is no evidence that any of the service users suffered any adverse consequences as a result of any cancellation or any resultant delay in either receiving information or in the performance of the abortion itself. There will, of course, be cancellations, we suggest, for other reasons, particularly in the case of women who haven't, in fact, yet come to a firm decision one way or the other. And it may be that the cancellation figures include the women who changed their mind as a result of having engaged with the appellants and other GCK supporters or members. As to the expectation of privacy, and this I would respectfully agree is probably what this third ground comes down to. That's the key issue. The learned friend relies on the 4 factors which Lord Nichols identified. He did, in fact, the expression that Lord Nichols did was to say that the exercise has to have regard to all the circumstances of the case, including, and then he sets out those 4 factors, and it should be remembered that that was a publication case, as indeed are so many of these Article 8 cases. As to the 12 intrusions that my learned friend addressed you on, we would submit firstly that they need to be understood in their context, and their context was a public place and a public highway. And what is intrusive in a private place may be very different to what is intrusive in a public place. The second general observation we make is that much of what my own friend said by way of those 12 examples of intrusion was overstated. For example, the first one, seeking out and identifying women of reproductive age approaching the centre. This is what this is the direct focus of the protesters. It amounted to non-covert surveillance. Well, with respect, that's not only a tendentious word to use, but it's inaccurate. This isn't sort of surveillance in the sense that we would all usually understand the expression. This is simply approaching. I mean, it's pretty obvious why the women are there. So the appellants approach them in the way that you've seen described in the first appellant statement, and then offer them the leaflet and offer them the to speak to them. And in no way can that, we suggest, be described fairly as surveillance. Other examples, and again I take this shortly, but it was suggested that the displaying of photographs of embryos at different periods of gestation could be, can only be designed to unsettle a woman, and it was said that that was one of GCN's key points that they were unwilling to give up in the course of negotiations. So I'll just give you a reference. Time doesn't allow me to take you to it, but supplemental bundle tab 5, page 18 will indicate that that's
in relation to which one?
In relation to whether or not this was a key objective that the difficulty is that when I give a reference at this stage of my reply with only a few minutes left,
I just wanted to know what this was. This still related to the first?
No, this is related to
which number of intrusions?
This is number 6.
That's what I need to know.
Yes,
number 6. That's what I was asking.
Where it was suggested that displaying these photographs is designed to unsettle a woman about her choice. That again is to overstate and mischaracterise the exercise. It's quite clear from what is said by both my friends that prayer is a problem for the local authority, even silent prayer, which is, we suggest, a very extreme position to take, and depends entirely upon the sensibilities of the service users taking complete precedence over all other factors. I mean, that is, just going back to my Lord the Master of the Rolls point put to my own friend, that is where we've got to. Those sensibilities or sensitivities have taken complete precedence in the balancing exercise over the rights, the Article 9, 10 and 11 rights of the appellants. And that we submit cannot be a correct outcome of the balancing exercise. Group vigils apparently are also to be prevented because they have the same effect. I repeat the submission I've just made. Conversations with service users.
I said the group vigil point applies even in relation to the designated area, doesn't it?
I think it does.
So we've got a maximum of 3 people.
Yes, it does. That's right. The numbers are restricted. But can I make the point that the group vigils only take place on Saturdays, and then, even then, not on every Saturday during the year. And you were shown by my friend in the course of her submissions a photograph which she said represented a typical day for GCN outside the centre, and I think she's right about that. I think there were 3 people there present, 2 maybe praying and 1 standing, not obstructing the way, but standing by the entrance, in order to be in a position to offer a leaflet and offer to engage with the service user.
You haven't got much time left.
I know.
One thing I certainly wanted to deal with, so I can put it to you at a particular point.
So the last one was, I was going to deal with 9,
Yes.
Conversations when service users leave the clinic. Again, if that is no more than offering to speak to a woman as she leaves the clinic, and if the woman says, no, I don't want to, stopping at that point, we submit that there can't be anything objectionable or unacceptable about that, unless the woman's sensibilities take precedence over everything else. Nor can there be any objection to leaflets being offered, I stress, to women as they leave the centre, and you have one such leaflet in the bundle. The attendance of the SS, the pro-choice group, needs to be treated with a little caution, we suggest, because they deliberately turned up in order to try to engage, to protest against the pro-life protesters, if that's the right word to use for them, and then went to the local authority and petitioned them, saying, you ought to stop what the pro-life protesters are doing. So this was a very deliberate, if not somewhat cynical, a tactic by the SS team to try to stop the pro-life protesters protesting at all, and query whether it is right for the council to, and indeed your lordship and my ladies, to take that factor, to give that factor much weight in the balancing exercise when that was the purpose behind it.
Well, there you've got, for at least on that point, you both agree. You both say that in carrying out the balancing exercise, you need to get notice of the pro-life, but for your own particular reasons.
Yes. My lady,
I think we would like to know, certainly I think we would, certainly I would like to know what you say about the submission that's been made by Mr. Base about the fact that what's going on here on your part isn't really about protest in relation to, or about engaging in a matter of public debate, and that all that's being done here is actually approaching specific women on specific times and occasions when they go in and out, and there's no contribution to a wider debate here. I think it would be helpful for us to have your response to that.
well, my lord, my response to that is that what underlies everything that the appellants and GCN are doing is the proposition that abortion is a bad idea. Hence, the attendance of the pro-choice group to make the opposite point. And that is my simple answer to the point, that demonstrates that the appellants were making a contribution to a point of general public importance, and the read across to the Annan case is clear, because Mr. Annan there was distributing leaflets, and indeed were distributing leaflets to members of the public, in which he...
Who's distributing leaflets?
Mr. Annan, in the Annan and German
Annan,
case,
yes,
the applicant in that case,
he
was distributing leaflets which...
He was distributing widely.
he did, well, he was widely, but that fact ought not, in our submission, to determine whether or not someone is engaging in a debate about a point of general public importance, because for the passer-by, let's take the passer-by, who will have seen on the one side the pro-life group and on the other side the pro-choice group, the passer-by will say, well, they're arguing about abortion, arguing about a point of general significant public importance. And that's why I say underlying what the appellants were doing was this debate. And it must have been, because behind all their actions was the proposition that abortion is a bad thing. And we want to persuade you that abortion is a bad thing and encourage you to think again about having an abortion.
What do you say about the points made by Ms. Bogle that wording within the order, such as interference and intimidation and the like, are basically ordinary words of English to be applied to the facts of any particular case, and they're to be found in various regimes, both within this country and elsewhere. And indeed they may appear in some forms of non-molestation order as well. What do you say about that?
Well, what I say about that is to invite you to go back to the two statutes that she showed you, which the back, I hope they're at the back of the authorities bundle, pages 769 and 771. And page, the US statute begins at page 769, and you will have noted that this is a statute expressly addressed to freedom of access to clinic entrances. So this is not just a general community protection statute, but over at page 770, the statute specifically defines what in this context interferes with and intimidates mean. So if you look just above the second punched hole, interfere with, the term interfere with means to restrict a person's freedom of movement. Now, many friends submitted that interfere with covers handing out a leaflet and seeking to engage with the service user. But here it's been defined in a very different way. Now, which is it? Is this the rhetorical question I ask? Same with intimidate. The term intimidate means to place a person in reasonable apprehension of bodily harm to him or herself or to another. So the US statute thought it necessary in the context of restricting access, in the context of providing something for freedom of access to clinics, thought it necessary to define those two terms. And we respectfully submit that they were right to do so.
What about the British Columbia one?
Well, my lord, again, the first point I make is that British Columbia has gone out of its way to address, by way of statute, access to abortion services. So, whereas in the present case, the local authority is seeking to use a PSPO to protect access to abortion services, the British Columbia statute has actually enacted a separate act. What the respondent has done is to copy and paste a definition of protest, that's on page 772, from the statute. But this was a statute that was addressed directly to protest and then apply it word for word to an act which was addressed to antisocial behaviour. So that's the first point we make. Indeed, what the respondent has attempted to do is to impose effectively a buffer zone, what's called an access zone in the order, around the abortion clinic, in reliance not on a statute which expressly addresses this, but on the 2014 Act. I'm told that in the United States, the Supreme Court has struck down such a buffer zone, and there's a reference to that in the dissenting judgment in the Ammon case. I think it's the Ammon case. At tab page 406. Hang on, page 406. Thank you, of the bundle of authorities. Where on the right, 406, first complete paragraph, 4 lines in, the United States Supreme Court has recently invalidated a Massachusetts statute that prevented pro-life activists from campaigning within a 35-foot buffer zone around abortion clinics, whilst the petitions in that case were merely offering women information about alternatives to abortion. It could be perfectly legitimate to distribute leaflets and run a website criticising abortion as a phenomenon, which the applicant continues to do. So as I say, the Supreme Court has struck down such an act in the US. Our researches indicate, my Lord must have asked this question, that the British Columbia statute has been upheld. It's been challenged in British Columbia. The challenge has failed, and the statute has been upheld in the first instance and in the Court of Appeal. But similar legislation in Ontario is currently being challenged. That's the extent of our knowledge. But as my Lord the Master Rolls pointed out, the difficulty with comparative law is that unless you know the precise details of the challenge and so on, but that's the best information we.
What about standard provisions in non-molestation orders,
well,
which has similar language?
I was rather busy over the short adjournment formulating my reply. The context, of course, is very different. This is a domestic context rather than it's targeted at specific individuals rather than across the board to a potentially wide number of people. I don't know whether such orders carry with them, long time since I did matrimonial work, whether such orders carry with them a power of arrest for failure to comply with them and a threat of imprisonment, but if they don't, then that's another point of distinction between them and the present case. They are, in some instances, plainly more specific, and if one looks at paragraph 11, the respondent must not use or threaten violence, so that's a less restrictive and more targeted approach. Must not instruct, encourage, or in any way suggest. And then we've got intimidate, harass, or pester, and then telephone, text, email, or otherwise attempt to contact. But as I say, and indeed there will have been, no doubt, specific evidence in each case, so that certainly the subject matter of the order will have a clear idea, no doubt from the judgment given by the judge before making such an order as to what it is that he or she should not be doing. So I would submit that there are differences between the two, but the key question...
You say those orders are made against a specific factual pattern.
Yes.
Which has been in evidence, and therefore the order, when it's framed, is reflecting a specific type of case of domestic abuse.
Correct. And I add that certainly when it came in the US to enacting a specific statute seeking to protect freedom to medical clinics, they thought it necessary to define, interfere with, and intimidate, and we submit for good reason.
Yes. So have we covered the main areas in which you would have wanted to respond? And I don't know whether anybody else on the bench wants to raise other areas.
No.
Those seem to be the principal matters. I think you've dealt with the line-by-line points. We've dealt specifically with the generality of the words. We've dealt with that. We've dealt with your proposition that effectively what's being done here is to negate any effective protest at all. You say that. I hope your learned junior has got here's waving something there. It's got the reference, very important, to the fact that the location of the designated area is such as to make any effective intervention meaningless.
I'm pleased to say he does.
Well, can we have a look at
Yes, it's supplemental bundle, tab 23, page 339.
What are we looking at here?
This is, I'm so sorry, this is the statement made by the second appellant in these proceedings. And if you go to, starting at page 339,
Is this one of the paid ladies?
yes it is, yeah. And if you go through to page 341,
This is all about unpleasant treatment. This seems to be a slightly different point.
well, the she goes on to a slightly different point, but in most of that section, she's
Right, I see. Hang on, let me see. Is it paragraph 11?
paragraph 11 is obviously part of it, but paragraph 9 as well, because of the uncertainties involved. And paragraphs 6 and 7, where she begins, makes the key point about the place. And paragraph 8, she's now offering,
It's really paragraph 7, is it?
paragraph 7 is the key probably.
Anyway, that's the best evidence.
And further back in the bundle, at 267,
Yes.
starting at the foot of the page, and then over the top of the page, the defendant has said that the designated area will allow women to approach us.
Sorry, we're 267.
But I'm sorry, it's the relevant passage begins at the foot of 267, goes on to 268, and at paragraph 41.
What is this document?
This is part of the
It's the statement of the second.
it's the second claimant's
Yeah.
statement.
Second page.
And top of 268, paragraph 41, she says that the reality is that the order, will largely nullify my ability to engage with women approaching the Ealing Centre. Particularly, the location of the designated area will prevent us from engaging with women approaching the Ealing Centre from the local transport hub of Ealing Broadway. Most of the women approaching the centre have no idea about the support we provide in the designated area. By design, would only allow me very limited engagement with people who walk directly past.
Good. Is there anything else? I appreciate we haven't allowed you to put in written evidence, but written submissions, further written submissions. But have we covered the main areas in which you wanted to make oral submissions?
Well, I think we have. I think just looking at the other points I would have raised, I think they are more points of detail than the main points in the case. And anyway, I'm reassured by the fact that I expect that your lordship would have put to me, and my ladies would have put to me, any of the main points that you wanted to put to me for my further assistance. So
I've allowed you to go.
you have.
Quarter an hour over. Very well. Well, we're extremely grateful to all counsel. This is a very important matter and a very sensitive one. We all appreciate that. We will carefully consider everything that's been said to us, the additional citations and references that have been given to us in the course of the submissions. We will hand down our judgment in due course. When you do receive it in the usual way, please agree a form of order. Any further submissions you wish to make on consequential matters must be in writing. Thank you both very much. And also...